case briefs, and so much more. LSData's got what you're looking for.
In a 1981 case heard by the Minnesota Supreme Court, Thompson v. Boysen, the court explored the idea that if a person revokes a will, the earlier will can be revived if it is clear that the person intended to do so. The court had to examine all the circumstances to determine whether the earlier will was meant to be used instead of the later one. Chris Boysen made a will in 1964 stating that his property would go to Raymond Boysen if he paid Genevieve Thompson $7,000. In 1973, Raymond Boysen became Chris Boysen's guardian, and the 1964 will went missing. Chris spoke to a paralegal about creating a new will, which stipulated that Raymond could have Chris's real property, but must give Genevieve a quarter of its value, equating to around $150,000. Genevieve Thompson appealed a court decision regarding the validity of the 1964 will, leading the Minnesota Supreme Court to determine whether Chris Boysen intended to use this earlier will or make a new one. Upon discovering that the will had been removed from the courthouse vault, the court decided to reverse the previous decision and remand for a new trial to determine the revival of the 1964 will. The Minnesota Supreme Court held that the district court must consider all relevant factors to determine whether Chris Boysen's 1964 will was valid after he created and destroyed a new will. The case has been returned to the district court for a retrial to answer these questions.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.